So good afternoon again, ladies and gentlemen. It is my pleasure to warmly welcome you to this public lecture on the Intestate Succession Act 1985, PNDC Law 111 at 40. The lecture is on its relevance, challenges, and emerging issues. On behalf of the Executive Committee, I'd like to say a very big thank you to all of you for taking your time. This is an extremely busy time of the year. We all know traffic is horrendous and everything, but you have honored our invitation and we do not take it lightly. We appreciate that. A little bit about Aula. Aula was the brainchild of our honorable founder and life patron, Mrs. Betty Mould-Iddrisu. She, together with a cohort of female lawyers, upon previous deliberations regarding specific rights of women in Africa, met in Nairobi, Kenya in October of 1998 and adopted the constitution of the African Women Lawyers Association. The aim was to strengthen networking between women lawyers of the member countries and advocate through legislative reform the enhancement of the legal status of women in Africa, among other objectives. Aula Ghana was registered as a legal entity in 1999, and under the able leadership of our founder, Honorable Betty Mould-Iddrisu, as I said before, and the then executive director, Ms. Edna Kuma of blessed memory, they steered the affairs of the association, making it one of the well-recognized women's rights advocacy NGOs in Ghana. Aula Ghana, together with other advocacy and civil society organizations, lobbied and spearheaded the development of policies and legislations to promote equal rights of women and remove all forms of, or an endeavor to remove all forms of discrimination against women. I mean, we all know that it has been an uphill task. The Intestate Succession Act, Act 40, 1985, has been one of the acts that has held the interest of Aula for many years. Thus, this lecture on its impact after 40 years of use by the court. The lecture by Honorable Betty Mould-Iddrisu will highlight the successes, the shortfalls, the challenges, and the proposed way forward towards making it an effective piece of legislation. The practitioners here are well aware of the many areas of the law that needs further discussion and possibly drafting. I shall not take any more of the time. Like I said, our time is far gone. So on this note, I'll just say thank you again for making the time to be here, so that we can have enough time to listen to what's the status of the act after 40 years in operation. Thank you.
Thank you very much, Madam Christine Latte. She is the chairperson of Aula Ghana. So Aula Ghana has put together some very important reflections on the impact of PNDC Law 111, which we would want to share with you this afternoon. So for the next 10 to 12 minutes or so, please sit back, relax, and enjoy these reflections that have been put together by Aula Ghana.
The Intestate Succession Law, otherwise known as PNDC Law 111. Depending on what marriage you encountered or you went into,
it was revolutionary,
game changer,
and it brought a lot of misery. We never thought that a government would come out to say, no, you cannot do this under customary law. Say that a spouse, and in this case, more often than not, we meant a wife, is not entitled to stay in the home or to be recognized as being a part owner of part of the marital property or the husband's property. We couldn't imagine that any government would come out and dare to say this, let alone to put it in not one law, several laws.
There were so many sorrowful stories. Some of the families would harass the widow in particular from the time the person dies until the funeral. There was one case I handled where shortly after the man died, the family came in there, put the TV and things in the bedroom and locked it. The man had a vehicle, they drove it to the family house. And so they basically just left the rooms where the children and the wife were sleeping. A very sad story of people being deprived of what they were used to enjoying when their spouse was around.
Wives and children being thrown out of the matrimonial homes and not being given any interest in the property, and they becoming destitute, even ability to pay school fees, to further education, or even to get money for day-to-day food. So this was a game changer in the sense that it secured the immediate nuclear family, their interest in the matrimonial, the property. Depending on what marriage you encountered or you went into, your circumstances changed. And so for different women in different parts of the country, depending on what marriage you contracted, your inheritance laws were different. So it brought some equity. It also helped with the enforcement of some of these rules relating to inheritance. Let us remember that it's not only women who benefit. My own sister, my half sister who died, she must have died in 85, 86, and the PNDC law 111 was applied. So it works both ways, and the beauty of it is that the nuclear family are able to benefit.
I must stand up here for Her late Excellency Mrs. Nana Konadu Agyeman-Rawlings. Those of us who knew it, who were associated with the government in one way or the other, knew that because of, at that time, the kind of work she did, she was very much involved in giving the push, the impetus to those kinds of revolutionary and groundbreaking laws. Because the injustice being perpetrated to widows wherever she went at the grassroots of the country was too much. Especially the matrilineal system of inheritance of Ghana.
There was a lot of objection, and it was this government machinery power in her husband, President Jerry John Rawlings, that really propelled and got the law passed. Chachu Chikata is also one of the architects. Obeda Samwa was the Attorney General and Minister of Justice then. So these are some of the key persons. But Nana Konadu Agyeman-Rawlings played a very key role. PNDC Law 111 was very crucial at the time that it was passed. And it is my conviction that it only passed because we were under military rule. I am very convinced that if we had tried to pass it at any other time, any other democratic rule, it would never have been passed. And I say thank you to the president at that time. He did women a very good favor.
For me, the law is working, and the quasi criminal provisions which the police have been made aware of, when it happens, we hear stories or they report to us that some family members are trying to deprive them, we direct them to the police. And usually the police will come in and make sure that they restore the properties back to them. So it has worked, but with a little bit of force in some places.
40 years later, we are still struggling with what the law is supposed to mean and what the law isn't mean. Every day there are new rulings in the High Court, and they are still bringing in heads of family to come and say what the law is, what the succession law should be, and so on. I mean, it's rather ridiculous.
There are educated women who it affects.
There are well-off financially, women who are well-off financially who it affects. And then there are the poor ones. They don't feel confident to enforce their own rights and stand up for their rights. Some of them are religious, some of them are social. So if the system, at every turn, there is a little bit wrong with it. It's not one thing that is stopping the proper implementation of the law.
A lot of people know about the name. You know, when you go to churches, you go to, like I said, we do the outreach, markets, churches, schools, etc. Many people have heard about the law. Some don't know too much about its content. So I believe that education still needs to continue so that everybody knows about this law.
PNDC Law 111 is also supposed to give us another leap. And with this, we'll be able to make society better. When we make society better, our children, it's not only females that we are looking after. We are looking after male and female children. So if it's good for the woman, the children, the whole of society will do well.
In addition to even the provisions about evisions, the law also makes it a crime to go and take properties out of somebody's matrimonial home as soon as a person dies. So it gives some protection, some safety. It's made women more confident, made them feel safer, and then that then makes it easier for them to contribute towards family wealth in the course of a marriage.
It's sought to give the immediate family inheritance of a deceased person, and the immediate family includes spouse and children who in our matrilineal system could not benefit from the estate of the deceased, especially in matrilineal systems. But then in patrilineal system, children could benefit, but never a spouse. But now the immediate family of spouse or spouses and children are catered for.
It's difficult to know how far to go. You know, as for the women, lawyers especially, we think we should go as far as we can, recognizing that we are born equal. But the custom holds us back sometimes.
More should be done than just leaving the factions out for people to battle in court. By the time they finish battling, half of them are dead, or their property is even dissipated. It leaves much more acrimony, makes families fight, knowing that this person has died interstate, and let's just have it that way and everyone goes to rest.
We need special provisions to address polygamous unions so that there's also fairness when it comes to how properties are shared when the person dies intestate. It would lessen the fights over who has a right to which one. And one of the things which is also key in the new bill is the law actually also makes a distinction between the share of the spouses and then the share of the children. And it gives the spouse the right to choose if there are a number of houses. Because some may be story buildings, some may be small buildings. So the whole thing is to try to achieve some form of equity so that nobody suffers.
Law is a tool to be used for change. So when people see that there is a need for a change in a particular way, and it will develop, it will help the country develop. It's not the country that should be ready for the law. It should be the law that should make the people change in tune with the law, because the law is a tool for development. One thing about laws is that sometimes it's good to just get the law passed, and then if there are any amendments in the future, you make those amendments, but the law exists.
And that's why different legal women groups have been established. So there's FIDA, there's AULA, there's the ACT Foundation, there's LEWA, and counting. So the angle that AULA can use is to collaborate with other groups like FIDA and then map out how they can continue with advocacy on the existence of Intestate Succession Law, so that together with other stakeholders they can ram it into the minds of people, change the mindsets of people that a spouse and children who survived a deceased parent or a deceased person have every right to their inheritance, to their estate, and to be protected by families, not, ejected by families.
I think it's not being applied as diligently as it should, and there are still lots of women falling through the cracks. It is only that there's a lot of communication today, and that's how we are able to see what is going on, but it has been going on for a long time. Some women just are not able to access the law, the effects of the law. And so the same awareness raising that we did in the past should have been continued every year. And then when more people's awareness is raised on the issue, maybe we'll get Parliament to to pass the amendments to the law, which have been sitting in Parliament forever.
I believe that there's still hope that it will be amended. Because remember, this law that we are passing, if you see somebody as a spouse, if people tend to think that, it's the spouses who are going to benefit, and then they would always say it's also the female spouses. Right now, we have a lot of women who are also doing very well. If you go to Makola Market, KJTR Market, Techiman Market, who are the ones who are there? They are very wealthy women who have also made money, and their male spouses also will stand to benefit.
That woman is not in a vacuum. It's related to you or to other people in a certain way. So the way we treat women should be looked at carefully. 1 minute you think it's another person's daughter who you are maltreating. Another minute it will be your own daughter who is being maltreated. And although the law is not totally adequate answering all our problems, I think that we should embrace it and work with what we have and ensure that at least the little that we have will give people what they deserve. There should be parity in the use of the law, and understand that every woman is a daughter, is a cousin, is a child, is related, is someone that has to be valued. So we need to take care of them.
The properties that she gets is supposed to be used to look after children, particularly when the children are young. They need a lot of resources to be able to grow up well, to become who, if their father was alive, would have become. So it's very important that this law is amended. All the challenges found with PNDC Law 111 as we have now are addressed. So we have a more holistic law which will benefit women and children of this country.
But above all, I will encourage people to write wills. Wills are so simple. They could be 1 page or 2, depending on what you want to write and the quantity in the estate. And then once you file it in court for a minimal fee, you know that your loved ones are secure and that they will go according to your will and abide by it. Otherwise, the Intestate Succession Law also prevails.
Gentlemen, those were some reflections on the impact of PNDC Law 111 by these wonderful women who have dedicated their whole lives fighting, or rather advocating, for the rights of women and children. I think we deserve another round of applause. So we are gradually moving on to the highlight of today's event. But before I introduce our distinguished lecturer for this afternoon, I'd want to do a few more acknowledgements. We also have with us here Dr. Joseph Wemako. He's the Executive Director for Human Rights Reporters Ghana. Doc, can we see you? Thank you very much. We also have some executives of Aula Ghana here as well. Please let us show some love for Madam Ifiba Ami here. She's the Executive Director of Aula Ghana. We also have Madam Ruby Agaglo. Auntie Ruby, are you here? Very key executive of Aula Ghana as well. We also have some faculty members of the UPSA Law School. Miss Mavis Kwenu, we all call her here, her ladyship. She's here with us. Mrs. Edna Aubry is also here with us. Thank you so much for joining us this afternoon. So I'll go ahead to introduce our speaker for this afternoon's lecture. And trust me, the profile is one that, if we are to start now, there's no way we are ending any moment soon. But our speaker for this afternoon is an accomplished lawyer with almost 4 decades of experience at the Ghanaian bar. Her career has spanned academia, both national and international public service, civil society, gender, and politics. She holds a master's in law degree specializing in intellectual property law from the United Kingdom's London School of Economics and Political Science, which is my alma mater as well, by the way. She has held various positions in the Ghanaian Ministry of Justice from 1980, including the position of Copyright Administrator of Ghana, a position she held for several years and received multiple awards for the innovative and cutting-edge work she pioneered in intellectual property law, not only in Ghana, but across the African continent. She was once appointed Director of the Legal and Constitutional Affairs Division of the Commonwealth Secretariat. This was in 2003. In that role, she managed the implementation of wide-ranging international law mandates from the Commonwealth Head of State, law ministers, and chief justices, and also served as a legal advisor on complex issues of law. On gender, she's widely recognized in several English-speaking African countries for her work in international law, human rights, and gender. She chaired both the Ghanaian and African regional groupings of the International Federation of Women Lawyers, FIDA, in the 1990s, and also co-founded the African Women Lawyers Association, AWLA, an organization which she chairs till now. She's actually a founder. She was in the vanguard of initiating Ghana's first legal aid offices in 1985 and spearheaded the empowerment of Ghanaian and African women through her grassroots programs for the sensitization of women and children in the areas of access to justice, judicial reform, and dispute resolution in several African countries. She also lectured at the University of Ghana's law faculty between 1990 to 2000. She has authored and co-authored and edited numerous papers and articles, and acted as a resource person, chair, and expert at multiple national, regional, and global fora on a wide array of legal and human rights issues. She worked as a consultant for over 20 years in the areas of international law, intellectual property law, and multilateral trade issues for the UN. Our speaker for today was appointed as Ghana's first female Attorney General and Minister for Justice in 2009, served as Minister of Education in 2011, and is currently a distinguished member of the Council of State. She is widely regarded as one of Ghana's top female politicians and an epitome of gender influence. She has unendingly spearheaded and collaborated with the CSO movement in engendering Ghana's decision-making process by progressive lawmaking, and lauded for exhibiting a high sense of statesmanship within and beyond her party. Ladies and gentlemen, it is my singular honor at this moment, and I would crave your indulgence for us all to be on our feet as we welcome our speaker for this afternoon, the Honorable Betty Mould-Iddrisu.
Please sit down. Now, I don't know why you did this to me. And I don't know why you and Marian did this to me. Just read some mini bio of mine. So if I had given you all 20-something pages, what would you have done? My very distinguished ladies, colleagues friends, and very distinguished advocates, some of you we have walked this path for many years. I don't want to start by, acknowledging everybody, but let me say that I am going to see my brother, my son, my junior brother, after the dean, after this lecture. I am also happy to see our honorable MP here, coming from the Women's Caucus, thank you, of Parliament, represented here. The police also, DOVSU, represented here. And then my sisters from the NGO, the CSO movements, those we started with, and those we are still in the battle with, executives of Aula Ghana, FIDA President, Lewa, the ARC, Angela, I'm so happy you are here. So, where do we start and where do we end? It's an honor to stand before you today to reflect on one of the most consequential pieces of social legislation in Ghana's history, our Intestate Succession Law, PNDC Law of 1985. And let me extend my sincere appreciation to my own executives and colleagues from the African Women Lawyers Association for organizing with Kofi Abochi, the Dean of the Faculty of Law at UPSA, organizing this particular afternoon. I didn't want to speak because I think that I've said it all. So I'm really not going to speak for very long, and I'm going to raise issues that the panel members should speak to. But 40 years, it's a long time. Let me say from the onset, Honorable MP, that we understand that Parliament is doing something about it. Today, as we sit here, the Parliament, our bill is finally in Parliament today. We thank God. And let's see what happens on the way forward. Today, I stand before you. I'm a very proud champion of the Intestate Succession Laws of Ghana. The groups we started off with FIDA Ghana, and later on the Aula, the ARC Foundation, Lewa, and many other groups. You may ask, why was it women's groups, gender groups that were talking mainly about this law? Because it affected us the most. I make no apologies for it anywhere. We were the victims. Yes, the law is gender neutral, but the law came about because of the systemic inequity that women faced upon death intestate of their spouses. Some of us here, we are old enough to remember what it was like for us, especially those of us born into the matrilineal lineage prior to 1985 and the absolutely awful, horrendous practices. This law changed it. It changed it. It emphasized or de-emphasized the role of the larger extended family. And this came about because the nuclear families became more, the role of the nuclear families became more emphasized. Before this law, spouses were often, and this included male spouses, because the FIDA Ghana ladies are here. They will tell you when we started the Legal Aid Center, we saw men as well. They were also disinherited by some of the customary laws and practices. Customary law provided very little protection at that time for surviving spouse, since neither spouse has a right to the property of the other. The matrilineal was the worst in its implementation. What started off, or what was tradition in those days, that it's a family, you belong to a large family, and the family usually own the property. We all know about our family houses, and we all know what happens when we have a funeral. It is the family that sits down, and it is the family in those good old days that used to bear the burial costs, to the extent of even going to borrow money and pay with interest. I've seen it in my little village. They pay with interest to pay for the burials. But times have changed, and during this time changing is when we saw the inequities that were perpetrated not only on women, but on children. Children might or might not be given a share of their deceased father's property. Women might or might not be allowed to stay in the house. They might be then dependent upon the whims of a husband who was given to them. At, you know, the tradition when you go after the burial, then they will give you a husband, or much to the men's delight, they will give you a wife. That one there was equality. The men got the women, and the women also got a husband. It was supposed to be figurative in those days. It was supposed to be so that there's somebody responsible. But we saw an awful distortion where children were often, more often than not given a share of their deceased father's property. The patrilineal system, as was mentioned here, you might get children inheriting some of the time. I had very shocking cases, though, I must say, which shocked me from the Volta region. Because usually, in the Volta region, Dr. Renee is nodding her head, she knows. Usually, in the Volta region, it's automatic, almost automatic, that children, male children, and the brothers of the deceased are the ones who would inherit. And yet, there were harrowing cases where we even had to go to court, and there were court injunctions obtained on the burial of Voltarians. Absolutely horrifying. On the court injunction in one case was obtained the night that they were showing it the night they went to bring the body for the waykeeping. People had come from all over the world, and yet it could not be. And I mean, the courts would reverse it, but it had already taken a huge adverse impact on the nuclear family. Customary law marriages, we must understand, did not regard a wife. Let me say this for the avoidance of all doubt. If you are married under the customary law, it doesn't mean to say that automatically you are part of your husband's economic unit. More often than not, the husband was automatically part of the wife's economic unit. But you were not part of making his money with him under customary law. Our plural legal systems should have worked better for us. There are some students here. You do know what a plural legal system is, where you have statute law, where you have customary law, and where you have ordinance law operating as the law of Ghana under the Constitution. And yet, it was the order of the day for customary successors to lock up the rooms of the deceased, throw the widow and children out of the house of the deceased, until maybe the widow and the children themselves would be so exhausted by what they went through, and then going to beg a head of family for your children's school fees because he has taken over the properties of your husband, was something that most spouses could not tolerate. So, my ladies and some gentlemen here, the year was 1985, PNDC Law 111. It's one of a bundle of laws. 112 was the registration of customary marriages. 113, PNDC Law 113, was the administration of estates. And PNDC Law 114, which really nailed it, was the head of family accountability law. i.e., if you are a head of family, you are accountable for the estate of your surviving, the estate of your family member. Let me just emphasize that without this bundle of laws, this package coming together, and with just the Intestate Succession Law being passed, nothing could have changed. Nothing whatsoever. But with this bundle of laws, which at that time, the ruling government did sit down. I've had several representations that they were there. It wasn't only Her Excellency Nana Mould-Iddrisu Rawlings, they were also there. And they sat for 1 week in cabinet, special cabinet sessions and looked at it. These were laws which were written by the National Law Reform Commission in 1985. The first time that it recognized the legal right of a spouse and a child to a share of their deceased spouse or father's estate and house in cases of death by intestacy. You know, why are we so particular about death by intestacy? It's because if you think you are a man or woman, go and tell your brother or sister that they should write a will. What happens? Hey, you know, up till today, I'm sorry to say this, and I won't individualize. I know of chief justices who have not written wills, of medical doctors, of professors, heads of chancellors of universities who have not written wills out of some morbid fear or some, antiquated notions. We need to get real in this world. Why should we still be standing here 40 years later talking about the law, lauding parliaments that after 23 years Was it 23 years? After, how long, when I laid the bill, that was 2009. How many years is that? It's today that Parliament is looking at it. Why should it be so important to us? Why haven't we moved on? And it's because of the centrality of Ghana's traditional and customary laws. PNDC Law 111 was introduced to provide, you've heard it all, uniform, fair distribution, protect the nuclear family, especially the women and the children, reduce litigation, ensure predictable outcomes, balance the tension between customary norms and statutory protections. The impact and the challenges were immediate. A hugely bold attempt to modernize family law and safeguard fundamental human rights. And yet, what were our achievements? And what was its relevance over 40 years? Let me tell you, I was very much part of it. I remember it like yesterday. Who else is here who would remember? Sheila, you are even younger. The families went about the business as if there was nothing had happened. 1985. As if customary law could not be legislated upon and that they were untouchable. It took the determination of a few group of women lawyers under FIDA Ghana. They were there last week at the FIDA Ghana's legal aid program we had. 40 years of legal aid. FIDA Ghana established the first national legal aid center in this country in order to address the needs of women because they couldn't get any protection under this law by themselves. And they were mostly unable to afford the services of a solicitor or a lawyer, even legal advice, as a representation in court. Most of the women at that time, in those days, were too afraid to even go to court. The few ones who were there, who came to us boldly. And I can remember some of them. I can remember some of their faces. Madam, anyone go court, my face one power court. It was rare. And they were emboldened because they knew we were there for them. But other groups took up the challenge as well, post-1985. And we were able to make substantial contributions to the implementation of the law. There's nothing more painful when you're a lawyer to see a law being written and then the law is unable to be implemented. It's like one of the passages which Dovsu has to deal with, where they set up a fund. They set up a fund for payment of medical bills. And yet, up to, I think, this year, not one, that is for survivors or people who go and report domestic violence. And yet, not one bill had been paid. I don't know if this year they've started paying the bills. What's the use of writing that into the law when there's nobody who can come out and say and push for it? This is the problem I have. Let me digress a bit, because there was a case in which we set up a team to seek justice for a woman who was murdered. She was murdered. She had gone and told her doctor. She went to see a dentist and told him that it was her husband who beat her and caused the facial injuries. 1 week later, the police were called in because they found her husband found her at 1 a.m. at the bottom of the stairs. Up till now, is it 3 or 4 years later? Do you remember that case? Justice for, I don't want to say it here. Up to now, we have been unable to prosecute. If that section of the law, which demands that anybody who comes with a complaint about domestic violence, the doctor or the medical specialist is in law bound to report that case. If the doctors would just have listened to that, this lady would have been alive to see her 2 teenage children grow up. Don't let me digress anymore. But these are the injustices that we are still fighting, and this is why we fought so passionately about this. The law guarantees surviving spouses and children definite shares in the estate. There was a reduction, there should have been a reduction in abuses of customary practices that we've spoken about. The courts at least gained a clear-cut framework for distribution of estates, reducing this dependency that we all have on inconsistent customary practices, even though the percentages or the fractions within the law are also a problem. PNDC Law 111 remains, therefore, a highly relevant, focused piece of legislation to protect spouses. And it is our duty to ensure the way forward. I'm going to raise issues with the actual passage of the law and leave it mainly to the panel to give us and all of us to discuss the way forward. I love this word. Can I pronounce it? Fractionalization. Have you heard of it before? Because the law says that, I don't know where they got that fractionalization from. 3/16, 5/16, 9/16, 1/16. How do you divide one house into 16 portions? How do you do that? How do you divide an estate into 16 portions? Then you say the one house should be given to the spouse and the child. Anyway, let me try and read before my mind is racing ahead. But it was immediately, in fact, when we saw the law first, we said, but what have these people done? Because we couldn't, it was too difficult to implement it. It was just too difficult in its implementation. And it surely led to confusion, to disputes, to administrative delays, to litigation amongst beneficiaries, instead of doing what a law is supposed to do, offering clarity and fairness. So conflicts were prolonged, property it was almost impossible to manage, mortgage, sell, or even use a property. How do you do it? And then, of course, what has already been mentioned here, polygamous marriages. Ghana's reality includes statutory monogamous marriages, customary marriages that have the potential to become polygamous, and then Islamic marriages, which permits polygamy. PNDC Law 111 does not provide in clarity a distribution formula for multiple spouses. As we saw, we've had to undergo a heartache in one of Ghana's most iconic musical figures, who I had the honor of mentoring and bringing him up when I was copyright administrator of Ghana. I thank God that he has been laid to rest now. I thank God that he has been laid to rest. The court cases were not the best. The situation was not the best. But any lawyer could have told you what should happen. Or, my ladies, any of us could have shown you the way forward. And yet, because of certain interests, things were not allowed to be what they are. The basic requirement that the matrimonial home be shared between the surviving spouse and children. You know where that problem comes. I don't have to talk much about that. Mostly, and let us be candid here, I'm sorry you men, but mostly men in Ghana, especially in those days, now it's a bit different, but men in Ghana did have children from different women. How do you say that a spouse and a child should share one remaining property? One property. There might be 10 children from 4 different women, and the spouse might not even have a child. Can you imagine? It was a very difficult situation. The law said nothing about it. The law said nothing about, mortgages or rentals or anything, or who contributed to buying the house in the first place. It might have been the children's first mother, the first wife of the deceased. It might be the current wife who he had no children with. All of us have done these cases. All of us. The cases abound. So this is one really serious issue. The Act also does not fully address stepchildren, because we don't have it in our customary law as such, a stepchild. But you know how it works in reality. The law definitely does not address cohabitation or long-term partners where the men have not gone to marry us. Where the men have not gone to marry us is another thing we have been fighting for. Recognize the fact that it is the men. We can go and marry, or can we go and marry under the customary law? I don't think that women can go and marry. I wish we could. Like they will see something. You men. It's stay with a woman 7 years, 10 years, 20 years sometimes. Nothing has been done. Meanwhile, you are the one who has bought the house. You are the one who has bought the cars. You have the bank account. You couldn't have a child. You are out with nothing and unable to get anything back. The Act needs to address some of those things and look at really what our situation is. And then also, we also need, my ladies who are panelists, to look at issues regarding the determination and distribution of jointly acquired property. This was also a huge thing recently. It's always been there. We need to look at it. And one thing that also I want to raise is there was no provision made for minors and children going to school beyond the fact that the children are, should be taken care of. But they didn't say that if a child is going to school up to the age of 18 or university, he should be looked after from the estate. And these are some of the issues which we hope, since now there's increased diversification of assets. Modern assets include digital, joint accounts, investments, pension benefits. Mostly, think about it. When you go to sign on for a pension or for the SNIT, most of the time we are not married at that time. So you put your mother, your father, your brother, or your sister. 30 years later or 40 years later, you don't go and change it, and then your husband or wife goes to see that he was nowhere part of your pension beneficiary. So we need to look at that. The new law should adapt. We also need to look at the many barriers. This was the heartache of the women. They just could not take the fact that they didn't have documentation. You know what it's like now to try and get documentation from the Lands Commission or State Housing, the extremely exorbitant legal costs, the slow estate administration process, and still the conflicts. Because despite all that we have done, cultural practices still influence property distribution. I think you have all seen that. These are just a few of the issues that have plagued PNDC Law 111. We need the way forward. We need the law passed. Honorable, we need the amended law passed now, today. 40 years later, we still have a draft Intestate Succession Bill, which I laid when I was Attorney General. I keep saying it. One of my proudest moments as Attorney General of the Republic of Ghana was to lay the Intestate Succession Bill before Parliament. And let me just say this: the property rights, property rights of spouses upon dissolution of marriage, constitutionally, we laid it. Sheila told me that who laid it before me? Jogate laid it in 2008. I relayed it in 2009. Kebashimene, Kopemene. But let's move on. They say today they are debating it in Parliament. We thank God. We thank God. We look to a new law to bring constitutional guarantees, to also look at our international obligations, and I'm sure Sheila and Angela will talk more about this. CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, the Convention on the Rights of the Child, the African Convention on Human Rights. We have to look at what is our family system today. How has it evolved? Who do you consider your family today when they talk about your family? And of course, we have to look at our gender equality commitments. This bill, and I want the students to understand this, is not just a legal update. It is a moral necessity for the people of Ghana. We cannot continue in this frustration for much longer. We are still operating the law with all of its inadequacies. 40 years. 40 years. But I will end soon by saying that AULA, the organization which I founded, co-founded, chaired for many years, helped. We have, in collaboration with our other sister NGOs and CSOs, consistently championed for access to justice for women, reform of discriminatory laws, protection of families, public education on legal rights. We have continued a partnership, and the other CSOs have continued this amazing partnership with the Ministry of Gender. We are happy they are here today. Parliament, most of the time. The Attorney General's office, we are happy she's here, a representative is here today. And civil society. We need to be together to drive these reforms forward. We, the lawyers, we need to understand what pro bono really means. Some of them here, I can see Yvonne sitting there, Ruby sitting there. Our monies, all our personal monies, went into assisting the women. Because if even you take them to court, and when they are thrown out of their homes, we are women. We were touched and we helped. But let us have the Bar Association, for example. There's a women's chapter of the Bar, pardon? A women's forum on the bars, doing something, providing pro bono estate administration assistance, engaging in legal literacy, advocating to Parliament the way we used to. I still remember Nanoye Bampuado, this affirmative action. One day we went to Parliament as a group. I went in another group. There she was downstairs in her T-shirt, shouting there, standing there, shouting, rights for women, rights for women. We need it. This is what has made us reach where we have. We need the research. We need to continue on the affirmative action path. We need to recognize that, yes, this is a problem for all Ghanaians, men, women, children. But it is more of a problem for women and children. And thus, we need to have a call to action. Parliament, we call upon you to prioritize the passage of the Intestate Succession Amendment Bill, and sit with us. And we can now tell you even that bill, it was 2008, 2009. We have discovered many more things that we need to have another look at. The government agencies, they must strengthen administration processes and public awareness. For example, in the case of marriages, Islamic marriages, how many are registered? And yet, it is a legal requirement to have an Islamic marriage registered before you can be a what? Wife. You know? That is the law of Ghana. And yet there are no facilities outside regional capitals to register Islamic marriages. I'm just giving one example. Traditional and religious leaders, they must work with us to eliminate harmful practices. It's not enough for the law to do it. I was just telling my sisters of a case just a few weeks ago where they are still throwing ropes around women, around widows, not widowers, widows at final funeral rites, throwing ropes. Something which has been banned, outlawed, and yet we are still doing it. And everybody was sitting down watching them until, as usual, I got up to talk plenty. So the legal practitioners, the academics, contribute towards research, as UPSA is doing for us today, joining us, partnering with us. The research, the advocacy, practical legal support for women, for children, And for the men, we've done countless cases for men as well. Civil society and the media, we need to keep this issue, keep it up in public consciousness. Every Ghanaian family should appreciate the necessity of writing a what? A will. As Sheila said, if it's even 1 page, Gloria, 1 page, 2 pages, it's nothing. You can do it. And it's our duty to also advocate. Now I'm bold, because I'm old. I'm bold. I ask people, have you made your will? Have you written out your will? You can do it and save so much heartache to people. 40 years ago, PNDC Law 111 responded to a national problem with bold legislative action. Today, we stand at another defining moment. We have the opportunity, you will agree with me, and we have the responsibility to refine the law and ensure that it continues to protect the dignity, the security, and the rights of families in Ghana. Let us continue to work together. God bless Aula Ghana, God bless FIDA Ghana, God bless the plethora of NGOs and civil society organizations. Thank you very much, UPSA. Thank you very much for attending. God bless you.
Thank you so much, Honorable Betty Mould-Iddrisu, for such an insightful and enlightening lecture. Like you did reiterate, let us work together to honor the spirit of the original act while still creating a strengthened and a modern framework that reflects today's realities. Thank you for your service to Mother Ghana, and especially to all the women of Ghana, Auntie Betty. God bless you so much. So we'll be moving on to our panel discussion very shortly, where we can further dissect the issues that were raised in Auntie Betty's lecture. But like I'm sure that you did hear her say quite a number of times that Parliament is very instrumental in this objective that we are all seeking to achieve. And we are very honored to have with us a member of Parliament who is also a member of the Women's Caucus, Honorable Nakoyo Okuno. She actually has a message from the leadership of the Women's Caucus and would want to welcome her so that she can deliver her message.
Good afternoon to you all. So I'm doing this on behalf of Honorable Comfort Doyu Kujo Gansa, who is currently out of the jurisdiction. She is the leader for the Women's Caucus in Parliament. Madam Chair, distinguished guest speaker, members of the Council of State, honorable colleagues, representatives from the African Women Lawyers Association, legal practitioners, academics, civil society organizations, students, ladies and gentlemen. I am deeply honored on behalf of the Women's Caucus of Parliament to participate in this important lecture organized by the African Women Lawyers Association Ghana, AWLA. I sincerely commend AWLA Ghana for their unwavering commitment to advancing women's rights, promoting access to justice, and courageously censuring the lived realities of vulnerable families within our national legal discourse. The theme for today's lecture, the Intestate Act 1985 PNDC Law 111 at 40, relevance, challenges, and its emerging issues, is both timely and significant. Enacted 40 years ago, I'm sure before I was born, the Intestate Succession Act remains one of Ghana's most progressive legal interventions. particularly in safeguarding the rights of spouses and children. Although promulgated during the PNDC era, the law laid a clear and uniform framework for the distribution of the estate of persons who die intestate, that is, without a valid will. It provides guidance on how property should be distributed among legal heirs, such as spouses, children, and parents, with a strong emphasis on fairness and the protection of the nuclear family. The Act replaced disparate customary inheritance rules with a more equitable statutory regime, specifying defined shares for beneficiaries and making provisions for household chattels and the matrimonial home. In doing so, it sought to override traditional norms that often disadvantaged women and children. Despite these progressive intentions, the practical application of the Intestate Succession Act continues to face significant challenges. Customary laws and practices still exert strong influence over inheritance, particularly in rural communities and in relations to family or lineages land. As a result, many widows and children remain marginalized, either unawares of their statutory rights or unable to enforce them in the face of entrenched traditional family structures. Another major challenge lies in the law's narrow definition of the word spouse. The Act recognizes only marriages contracted under customary law, the ordinance, or the Mohammedan law, thereby excluding cohabiting partners, regardless of the duration of the relationship or the existence of children born within such unions. Furthermore, the law makes assumptions that do not always align with contemporary family realities. For example, it presumes that the surviving spouse is invariably the most suitable person to care for all the children, including stepchildren. This often leads to tension when stepchildren and the surviving spouse become tenants in common of the sole matrimonial home. Now, access to justice also remains a critical concern. The law assumes a level of awareness and access to legal services that many Ghanaians, particularly those in rural and underserved communities, do not possess. Limited knowledge of statutory rights and financial constraint often prevents affected persons from seeking legal redress when disputes arise. Additionally, the Act does not adequately address polygamous marriages, a reality in many Ghanaian communities. This omission creates uncertainty and conflict when multiple spouses and their respective children lay claim to household chattels and the matrimonial home. There is worth nothing that Parliament has been actively engaged in efforts to amend the Intestate Succession Act through the Intestate Succession Bill 2022. The proposed reforms aims to create a more uniform and responsive legal framework, strengthen protections for surviving spouses and children, addressing existing anomalies such as estranged spouses, benefits from estates, and harmonizing statutory provisions with involving family structures. Unfortunately, the bill has lapsed, making renewed advocacy more urgent. But the good news is, today, it's being debated. This public lecture, therefore, provides a vital platform for reflection, honest dialogue, and courageous problem solving. Our discussions must move beyond sympathy to create action towards reforms, education, enforcement, and cultural change. I encourage that resolutions arising from this forum be forwarded to the Honorable Attorney General for consideration and possible incorporation into a revised bill for resubmission to Parliament. We are particularly honored to have our mother, Mrs. Betty Mould-Iddrisu, a distinguished legal luminary, also a former Attorney General of the Republic of Ghana, and a member of the Council of State, to deliver a keynote address highlighting on most of the things I have also enumerated on. The Women's Caucus of Parliament assures AULA and all stakeholders of the continued partnership in advocating for reforms that genuinely protects the rights of women, children, and other vulnerable persons. We remain firmly committed to using our legislative and oversight responsibilities to ensure that our laws serve their true purpose, that is, to protect, not to abandon, to heal, and not to harm. I wish all of us here a robust and a productive discussion, and I am confident that this forum would contribute meaningfully to shaping a more just inheritance regime in Ghana. Once again, I congratulate AULA Ghana for this timely and compassionate initiative, and I will wish all participants a fruitful and impactful deliberation. Thank you, and God bless you all.
Thank you, gentlemen. Those were some reflections on the impact of PNDC Law 111 by these wonderful women who have dedicated their whole lives fighting, or rather, advocating for the rights of women and children. I think we deserve another round of applause. So we are gradually moving on to the highlight of today's event.
Thank you very much, Auntie Betsy, for the sensational lecture. You have reminded us again that the PNDC Law 111 was revolutionary, but now it's time for change. And so, with your kind indulgence, Madam Chair, Madam Lecturer, all protocols already observed, I'd like to invite to this stage a few aspects on the subject, those who have helped to implement this law, those who have fought with this law, those who are still fighting to improve upon this law, to help improve upon the status of women in Ghana. So the first person I would ask you to help invite to this podium is our very own Auntie Sheila. Mrs. Sheila Minka Premo. She's the founder and managing partner of Apex Law Consults, and she is a consultant. Everywhere there's gender, there's Auntie Sheila. Anywhere you hear gender, you see Auntie Sheila. So thank you very much for joining us. We would like to invite next my very own auntie, Auntie Oswa. She's the head of DOFSU National. Thank you very much for coming, ACP Oswa. We have next Madame Georgette Francois.
She's a lawyer. She's a member of the National Peace Council. And she is the chair of the Ghana Association of Arbitrators, chartered certified arbitrators and mediators. Finally, we have Madame Mercedes Kunedu-Marie. She is the Principal State's Attorney of the Office of the Attorney General. Thank you very much for joining us. As we engage the panelists, I encourage all of us to think about three things. How well does PNDC Law 111 respond to today's family realities? Where does the law fall short in protecting vulnerable persons? And the last one, what practical reforms, legal and non-legal, can make succession less adversarial and more humane? So as we engage in this discussion, think about these three questions. We'll welcome questions at the end of the panel discussion. Hopefully, your questions will be answered at the end of the panel discussion. But if you still have any more questions, please try to make them straight to the point and very concise for us. We are already far behind time. Thank you very much. Okay. I'd like to start with our head of DOFSU. Auntie Uswa. Everybody's my auntie on this panel. Auntie Uswa. Straight to the point. Can you let us know what forms of violence arises as a result of intestacy where there's conflict? What are some of the issues that DOFSU has to handle? What are some of the practical ways that the law currently, the Domestic Violence Act, and also the PNDC Law 111, what kind of protections does it give these vulnerable people, and how is DOFSU able to help these people?
Thank you very much. It's an honor to be here, to be part of this great discussion, and to also learn from Her Excellency, Mrs. Betty Mould-Iddrisu, and our big sister, Auntie Sheila. We always work closely with her, and then Madam Angela, and then Fida as well. Thank you very much. So, yes, the PNDC Law 111 is very critical. It's a very important law that protects a woman. Some of the offenses that we come across, or some of the issues that come before us, obviously is intermeddling in disease properties. Most of the times and it's normally the women and children who are victims. So as soon as the man dies, then the sisters, the uncles, and the aunties, and whoever would just barge into the home and then enter the bedroom, start locking the locks and all that, and drive the woman out of the house and lock the house. And then it comes with denying them access to monies that they could use till the estate is shared. So these are some of the offenses. Apart from the intermeddling too, you have the issue of assault in instances where the women are beaten. And so we talk about emotional abuse, verbal abuse, economic abuse. So in this day, we just don't only apply the PNDC Law 111 because we have the Domestic Violence Act as well. So when you come, we don't limit ourselves to intermeddling, but we'd also extend it to for offenses under the Domestic Violence Act. So yes, the law protects the woman because it helps it's to prevent women or spouses and children being driven out of the homes. So in instances where we've had such situations, it's an opportunity for us to educate the people who fall foul of the law to draw their attention to the fact that this is their matrimonial home and you cannot drive them out until either a law is read or you go through the necessary legal procedure for the properties to be shared. Instances where we always, for us, our priority is security. We always think about the security of the spouse and the child. So if from investigations we realize that it is not safe for the woman to go back to the house, we find an alternative, or we suggest to them to find an alternative, because if we are not careful, we might insist that, oh, it is her right to go to the house and ask the woman to go back. At night, at dawn, you don't know what could happen. Anything could happen. So we try to, some of the practical ways that we adopt is, the fact that you are out of the house does not mean that you've lost the property. We are looking at, because we are police, we are looking at security. So sometimes we prefer that you go into hiding until the necessary legal steps is taken. And most of the time, when you bring them before the court, it puts some fear in them and it stops them from going back to harass the people. Thank you.
Yes, you did. Madam Georgette, my next question is to you. Can you tell us some of these issues and situations that has come to ADR? I'm asking this specifically because you're an ADR expert. Is ADR a best solution to resolve some of these issues? What are some of the practical issues that have come before you? And how does ADR help to resolve some of these situations?
Thank you for the opportunity given me. And let me say that I'm highly honored to be here to join in this celebration. And congratulations, Aula. Congratulations, Auntie Betty. And as I stepped in and I saw some faces I haven't seen for a long time, my mind went back to down memory lane. 1983, when I became a lawyer, 84, Auntie Betty, visionary leadership, galvanizing us. We were fighting for women and so on, and we had challenges in the courts. And I want to congratulate Auntie Betty for her vision. All these years, she's still the light leading us on this path for women's rights, especially when it comes to distribution of property for spouses. Auntie Betty, thank you very much. So please repeat your question.
So my question is, if ADR is an appropriate place for resolution of such conflicts, can you give us some of the conflicts that you have been able to resolve with ADR?
ADR, as you all know, is referred to as alternative dispute resolution. It's an alternative to litigation, and it comprises of several different processes: mediation, arbitration, early neutral, evaluation, so many. We have over 20 different processes which can be used. There are different techniques which are used to resolve cases or matters or disputes outside litigation, outside the courtroom. And I think that ADR in its current form should be the first option for litigants or prospective litigants before you go to court. Because sometimes when you apply ADR mechanisms in resolving the disputes, sometimes even in one day you can have the dispute resolved. Sometimes the parties just are not seeing the dispute from the other party's perspective. Sometimes it's just about one party saying he's sorry, asking for an apology, and then the dispute is resolved. But once the case is filed in court, the lawyers who are filing the case do not have the tools to deal with the emotional side of the dispute, because we are trained in the adversarial approach. And you file your writ, the plaintiff claims this, the plaintiff claims this. Can the plaintiff go to court and say, he was rude to me and didn't apologize, so I'm going to punish him by driving him out of the house? You can't say that in court. But you can address that issue in ADR. ADR addresses so many issues, and it is what we call a process that tries to achieve a technique called the triangle of satisfaction. In ADR, the goal is to get the parties to be satisfied with the process. If they are satisfied with the process and they are okay, they will not continue to fight. If they are satisfied with the substantive part of the dispute, they will not fight. If they are satisfied with the psychological or emotional issues in the dispute, invariably, they don't want to continue to fight. There are several cases involving intestate succession that have traveled from the high court, even sometimes from district court to court of appeal to Supreme Court and so on. Sometimes it takes so many years. And the problem and challenges we face with litigation, it is not only the money, it's not only the expense or the time factor or the fact that it just stresses people out and actually destroys relationships. But ADR, when applied properly, is timeous. It settles disputes quickly. ADR is so beneficial, it can even help to preserve the relationships, because if the mediator is skillful, he will address the emotional problems behind the dispute. People go to court because they have emotional problems. They have emotional problems, but they are not able to express it in court. And why do people fight? Why are people fighting? Because they are in a relationship. If you don't have a relationship with somebody, will you go and fight the person? You won't. Take the popular case of the Palestinians and the Israelis. They have been in a relationship since centuries, biblical times. Palestinians were called the Philistines, and they have been fighting. They have been fighting. The Ukrainians and Russia, they were fighting. They are fighting because they have a relationship already. So people fight because they have relationships and because they have certain unique needs, and everybody is competing for a particular need. And that clash in the competition generates the dispute. Thank you.
Thank you very much. So it's great to know that ADR is great for such resolution or the resolution of such disputes, especially because we want to keep the family ties together. We don't want to broaden or widen that gap further because because of the special relationship that we have in matters of intestacy. Everybody's a family, or it's a close family unit, and so we want to keep it. Auntie Sheila, since you're holding the mic, what is the way forward? We've already acknowledged that after 40 years, the law needs to change. We need to ask certain things. Some things have changed with family dynamics, with the way that we are. We need to protect the vulnerable further. So what is the way forward with us?
Okay, thank you very much. I'm also honored to be part of this panel, and I'd like to congratulate Aula for celebrating 40 years of Intestate Succession Law. It's a very important and significant law which has helped women and children in particular. So we'd like to commend Aula for this initiative. In terms of the way forward, as has been indicated, since the early 2008, 2007, even from 2005, a lot of work has been done, a lot of research has been done, and there's been a bill in and out of Parliament. In fact, the bill has gone to Parliament about 6 times. And so one of the things we need to be certain about is that we need to give it the final push this time round for it to go. I always remember in my work that I've done in doing some of the research into it, we had a meeting at the National House of Chiefs. And what some of the chiefs said was that this was a law passed in 1985 which made a big change in customary law, and they were not consulted. So there are lots of stakeholders who are very angry that that law even got passed and it's benefiting women and children. So we need to push for this law, and we need to engage. We need to lobby members of Parliament. We need to identify some champions there so that they will be champions within Parliament. We need to also lobby some of the key stakeholders. I mentioned the National House of Chiefs. There are ways in which you can approach them. The National House of Chiefs, the Constitution itself gives them the mandate. If we look at Article 272, it says that they are supposed to undertake studies into customary law, see the ones which are inimical, and come up with proposals to address it. So we should find ways in which we can address some of these people who think that they own custom, and let them see the rationale, the reason for the change. As Auntie Betty was indicating in her presentation, one of the key changes that is in this law is to align it with constitutional provisions. We have our own constitution, 1992 constitution, Article 22. 22.1 says that there's a need to ensure that each spouse gets a reasonable share of the other spouse's property if they die, whether testate or intestate. For testacy, we have the Wills Act, which has some provision, but for intestacy, we have the Intestate Succession Law, but we've seen a lot of problems with it. I think because of time, Auntie Betty tabled some of the laws, issues about polygamy, issues about fragmentation of the estate, especially when the children come from different women, when a man dies, etc. So we need to do that. So the advocacy which has been going on for years has to continue. We need to be able to undertake, write articles and get the public to be able to accept that there's a need to change this law. It's a very good law which has helped a lot, but there are challenges with it so that the law becomes easier. For those of you who've seen the drafts of the older bills, etc., it changes the fractions, which is a problem, into ratios. I'm not good at maths. People tell me that the ratios and the fractions are the same, but it looks nicer on the eye, because when you're talking about taking one house and household chattels out, and if there are 2 houses, the rest is the residue is supposed to be divided into 16 parts. How do you do it? It's practical application is very difficult. So maybe the ratios will make things better. Again, provisions are there for people in polygamous marriages so that there's equity between they and the man, as well as among the women themselves in terms of the sharing. And so I think that we need to write more articles for that. Is something that we can all do as stakeholders and continue to educate people about this law and some of the challenges. As you heard from the police, even in this day and age, people still try to abuse people's rights by still trying to, the usual Monday following the funeral, family members still try to make inroads and try to still deny people their access. So education still has to continue. Education is important. So the key thing is to push this time around. This should be the final push to get this law passed. We should get the speaker on our side so that it will be tabled more and more for debates. we should also make sure that, as I've already indicated, get some key persons in Parliament. There's my recent experience with the affirmative action law and bill, which we also pushed to get passed. And there are some things that was done. We need to. And one key thing is to also get the Minister for Justice, who is the one who would laid the law. We need to have him on our side and working with him through the process. You know, it has happened. It happened when it came to affirmative action law. We had the minister then working with us to be able to get this done. So it can be done, and we have a responsibility to come together as women, as advocates, to push for this law to be passed.
Okay, thank you very much, Auntie Sheila. Mercedes, you have heard Auntie Sheila. So what is the challenge with getting this bill passed? Tell us what the current status is. We have heard today that Parliament is discussing it today. I dare say it has been as a result of the push Aula has been doing for the past couple of weeks. But it's good news that Parliament has it today. So what is the current status? What are some of the challenges that has gone on with the passage or lack of this current bill? And then, like Auntie Sheila said, how do we get you on our side to make sure that this is the last push?
Thank you very much, and I bring you greetings from the Honorable Attorney General and Minister for Justice, Dominic Akutenga Ayine, the Deputy Minister for Justice, Dr. Justice Remsai, and special greetings from the Solicitor General, Mrs. Helen Awo Akbenizi, who should have loved to be here herself. She brings her greetings. Thank you very much, and I'm honored to be here. Auntie Betty, congratulations to you, and to Mrs. Ofori-Boadu, FIDA President, thank you for the many number of days of activism. Auntie Angela, thank you so much. The status of the bill, it's in Parliament now. There's a new one. The last one was actually signed by the outgone AG, and it was dated, I believe, April 2022. Yes, so the 2025 one is to be laid in Parliament. The challenges have to do with the notion that it is us against them, men against women. That is one of the, because we seem to get a lot of pushback from the male side in Parliament. I believe there has to be more awareness creation, understanding, and as Auntie Sheila is saying, lobbying. We need to get them to understand that it is not a gender-sensitive act or bill. It is to protect everyone. It can be your sister, it can be your child. You never know who it is. Yes, it is true that to a very large extent, it is the women and children who are the vulnerable. There are rich women in town, yes, but the majority are the widows and the children. So when you look at the new bill, it grants some form of security better than what we have now in terms of jointly acquired properties, for instance. So what the new bill seeks to do is to take out jointly acquired properties. The current one assumes everything is for the man or the deceased, the intestate. But this one makes sure that any jointly acquired property is taken out before sharing goes on. Auntie Sheila was talking about the ratios. Yes, now it is clearer. Half. 1/4, finish. We don't have this 8th, 16th, we don't have all those things. So when they look at it, they feel our properties are going to go to somebody else.
So make a will.
Yes, we'll come to that. We'll come to that. I remember I even told my father to make a will, and he said, human beings don't die just like that. And then one fine day, he had gone to do his medicals, gotten a very sweet report. I was going out and I was called that he's at C&J. I'd never seen my dad like that. When we transferred him to Kolebu, he said, can you call your friend for me, the lawyer who wanted to do the will? I said, so you see that human beings can just die like that. But it's a subject we don't talk about. like Auntie Betty said, make a will and they won't do it. Yes. So let's work with what we have. Now we are having this discussion. I'm sure things are going to come up. We can make some insertions. One assurance I can give you is that the Honorable Attorney General is very keen on seeing this bill passed. It's been in and out of Parliament from 2009. That is not good. So we need to engage the parliamentarians, especially the men. It is not a fight. We just need to get things done. Forget about the surviving spouse being a woman. What about your children? The ones you have outside that only pop up upon your demise. They are all going to be catered for under the law 111. We cannot run away from the fact that it has been a cornerstone law in our country. It has brought equality. It has brought some level of security and certainty when a person dies. When you look at section 17 of law 111, it actually makes the offense of intermeddling a 1-year jail offense if you don't pay the fines. The new bill makes it 2 to 4 years. So it tells you that we are serious about protection of the surviving spouse and children. So let's have more stakeholder engagement, dialogue, and putting what needs to be put in now, so that when we give it a final push, we know that we have a good document that we are working with. There are digital assets now, we have financial instruments, all those things in the past were not catered for. Now the reliance on nuclear family is not like as it were 40 years ago. Let's ensure that we fine-tune all these things so that when we push it, we know that for a good number of years we are safe. So the status of it is that it's going to be relayed, signed by my Honorable Attorney General, and good things will come out of it. Let's give ourselves to the end of next year to see this bill passed. Thank you.
Get you to stand with us.
We are standing with you. We are standing with you. Even though it has lapsed, the topic has come up in Parliament today, and that is a good step. That is a very big step. So let's all, we should dialogue and have more stakeholder meetings. Auntie Sheila knows. I mean, we can even identify those who are giving us the massive push back. Let's go to them. Let's explain to them. Some honestly do not understand what is written in there. They've heard snippets of it. They've not digested it well. So we need to sit down with them, lobby, discuss, explain, and listen to them as well. Like I'm saying, it is not us against them. We are together in this. Let's make everybody feel a part of the journey so that the chiefs won't say you didn't consult us. We need to explain to them that yes, under Article 11 of the Constitution, customary laws are part of the laws. But where it conflicts with constitutional rights or it's inimical to some persons, then we will override it. Let's explain it to them. No chief will come out to say that I want you to scrape a woman's hair as part of widowhood rights. No, they want to feel a part of them. So let's carry them along, and we'll see that this bill will be passed. Thank you.
Thank you very much. I am sure that as you do further stakeholder engagements, Aula Ghana would help partner with the AG to make sure that some of these advocacy are done. Would like to know what is in the current bill so that we can also use it to properly do some of these stakeholder engagements and then hopefully contribute towards additions onto the new bill. Thank you very much. I have a few questions already I would like to ask. I think the first one will be to you. What assurance do we have that the current state of the bill will be accepted by the men in Parliament?
I am unable to give you one assurance. It still goes back to dialogue. Okay, FIDA Ghana, ACT Foundation, Aula, we need to have engagements. And it shouldn't be a 1 week, 2 week engagement and then we all go to sleep. It should be constant. Aula should come to us at the AG's office, FIDA Ghana. There used to be times when I could go render pro bono services at FIDA. we have legal aid, because legal aid will have statistics, FIDA will have statistics, ACT Foundation will have statistics. Auntie Sheila, I'm sure you have statistics of all these. When we put it before them, they then see the reality of it. How overnight the fortunes or the future of a child is changed because of the loss of a parent. They need to see these statistics. We have to back it with data. So when we do that and we do it consistently, it will make an impact. It shouldn't be after 40 days of activism that we go to sleep, because they think that they are protecting their properties from women. And I dare say that some women in high places also see this bill as immoral. Yes, because it's not going to cater for the side chick, it's going to cater for informal unions, it's going to cater for cohabitation, children born out of the matrimonial home. So sadly, they also step in to frustrate the passage. So let's look at all those things holistically. Yes, we don't have illegitimate children in Ghana. So we need to cater for everybody. So let's talk to both sides, engage, dialogue, and it is only when we do that that we can get assurance that it will pass. Thank you.
Thank you very much. I have a question. I'd like to ask Auntie Angela, please. Yes, I think you're the best person to answer this question. Please forgive me. But a question, let me read a question. Sometimes, when we talk about interstate succession, it seems far-fetched. People do not appreciate the intensity of the abuse or its effects on the vulnerable. Can you tell us the practical examples or cases that you have handled where women and children have faced more than just deprivation of their inheritance?
Ma'am, this is ambush.
Oh!
Yeah, I take care of abused women and children. But anyway, thank you very much for that question. Just before I say anything about it, a few things are going through my mind. Tell Dominic Ayeni that he should hold that stakeholders meeting, that we can all come, because NGOs, we don't have money. The state should also do these things so we can come in there and put in the expertise. So, one message. The second thing, very quickly, has to do with some of the amendments, very important amendments. For example, taking out the property rights, the marital property or the joint. It is being confused by current Supreme Court decisions. So it's going to have a bounce back on the arrangements that are made under this bill. What exactly is joint property during the subsistence of marriage? Every day we are getting a different decision. So I think we need to talk about that in some of our dialogues. Very, very important, because that's what's going to be used as a roadblock. You see what the Supreme Court has said very recently is in graphic. Didn't you see it? You know, yes. So that's another thing. But then back to your question. Yes, we've seen, just a few days ago, I was walking somewhere in a town someplace, and a woman came screaming, "Oh, auntie, you helped me." I can't even remember. They threw me out of the house when my husband died. I want to hear me, and how you fought for me. And then I remembered, this is years ago. She came so desperate, crying everything. Me, I did what I can do for somebody who is traumatized. Then I cuckooed her and gave her to Gloria and her people at FIDA. You know, so they did the fighting part in the courts. But that's how working together helps us. And that's one typical example. You should have seen her and she's not the only case. You know, it's harrowing when you see how traumatized they are. And there is actual occupation. Sometimes they won't come and lock the door, they'll come and occupy the place until you and your children have to get out. So even if they don't lay a finger on you, the trauma you are facing of having lived in a house for several years, sometimes there was one woman, like 45 years of marriage, and the house was occupied. She came to me with nothing, crying. as usual. But again, working together helped sort out her case. So we need to think about the traumatic effects that these kinds of actions have. And I'm happy the intermeddling thing is going to be tightened so that nobody will even dare go there immediately after a death is announced. So, I mean, this one we can talk about for a long time.
Thank you very much.
Please, thank you for this opportunity. Please, I wanted to ask the types of alternatives that DOVSU suggests to spouses in cases where they have been sacked from the house. In case where the spouse is not a citizen of the country and there's no embassy around, and the person can locate any person's residence to go and base for that time in case the person is in type of fear. Like, what are the initiatives that DOVSU will take into place? And my second question is, please, do you think the bill that is being deliberated on by Parliament at the moment needs to take account the enforcement of foreign decision of the court, of a foreign court in interstate issues? Like when an individual from a different country comes with a decision from another state concerning interstate issues, and that state is not under the court's act as being one of those states that Ghanaians will take into place. Thank you.
Tell us your name and where you are.
Please, I'm Michael Amabo.
Thank you. I'm DSI Janet Ankra from Ghana Immigration Service. And please, throughout the discussions, I've not heard of a situation whereby the spouse, the current surviving spouse, preventing the other children from having part of the property. Let's say the first wife, they separated, 15 years later, they acquired the land, built the first house, before the second one came. And when he passed on, now the lady doesn't want to recognize the first child and preventing him from coming in and wants to acquire everything for herself and the children. What is the law saying about that part too? Thank you.
Any other? Okay.
Thank you very much, Dr. Joseph Wemako, Executive Director, Human Rights Report Desk, Ghana. So I happen to have listened to all the conversation that went on, the speech, the lecture that we've heard, and it beats my imagination to realize that this particular PNDC law has been something very instrumental, but then I guess the justice system itself does not favor us when it comes to delivering justice. And I want to find out from you, over 100%, where do you think this law has failed us if it is inadequate? It could be that it's inadequate, or maybe those who are interpreting the system, the justice system, are not interpreting it the way it has to go, because the law, as we know, has been instrumental. But over 100%, I would like to know where somebody can give us the mark, and let's find out if the judicial system has not lived up to its expectation in interpretation, and then we move on what has to be done to make it holistic. Thank you very much.
The first question goes on to Uswa on the alternative accommodation that DOVSU gives to vulnerable people or victims of abuse during this interstate succession.
Did you say when the person is a foreigner or something? Did you say foreigner?
So he gave, the first was what are the alternatives?
Okay, the alternative. So, okay. So it's shelter. We provide shelter and we work closely with ACK Foundation. So in some situations, if asking the woman to go back to that environment could lead to further harm or even death, we want to prevent crime before it happens. So we get in touch with ACK Foundation. Currently, we have our own temporary space. So depending on the situation, during the time you came, we would keep you. Normally, we prefer to keep you because a case is under investigations, it will take you to ACT Foundation. It will mean transportation in and out. Anytime we need you, we have to come in and take you. So normally we'll keep you for a minimum period of time for the investigations, and afterwards we will hand you over to ACT Foundation, so shelter.
And then, Auntie Sheila, I don't know whether you take the question on foreign decisions, whether they are considered foreign decisions on intestacy or foreign pronouncements on intestacy.
You know, a human being always dies at one place. You know, the person may be a foreigner, may have died here. The Intestate Succession Law would apply to that person. There are provisions in it regarding that. I don't know which other circumstance you have, but there are rules, we call it conflict of law issues, which depend on the actual matter. It will be determined. But under this Intestate Succession Law, as we have now, if you're a non-Ghanaian or a foreigner or whatever, if you die here, the rules, you don't have a will, and your family members want to take that, to deal with the estate, etc., it can be done here. Even if you don't have any relative here, it is possible for certain steps to be taken with regard to your estate. And if you don't have anybody to inherit, they say that the estate will go to what? The state. You know, so there are all kinds of rules which exist when it comes to non-Ghanaians or foreigners, etc. I don't know the particular facts you have in mind, but there are rules related to conflict of law, and the judges take all these into consideration. You know, when somebody dies, you don't just go and apply the intestate succession law. You have to go to court. If the person dies without a will, dies intestate, you have to apply for what they call letters of administration. So some of these issues can come up, and then decisions will be taken. If the person dies with a will, that is dies testate, then they have to apply for something that we call probate, and then all the rules and things would apply. So for now, this in short is what I can say.
Okay, the other question was the surviving spouse preventing stepchildren from inheritance or from benefiting under the estates of the deceased. Anybody else can take this?
Want to say something?
Thank you. If you look at the provisions of the Intestate Succession Law, all children of the deceased are entitled to inherit. So if a surviving spouse decides to ostracize some of the children, it's unlawful. So they can also go to court and fight for their rights. I just, as I was coming, somebody called me. The father has died. The father had 2 children with a wife, and then 2 children with a side chick. In fact, one of the 2 children has died. But when the father died, the daughter from the side chick has been prevented from coming to the matrimonial home. She even asked to be given a boys' quarters. She was living with her husband, and her husband has died, and she has 3 infant children. And they are still saying they will not allow her to even use the boys' quarters. So I was educating her on the rights. But these are things that always happen. And the point is that because should I say, people are not aware of PNDC Law 111, the provision. When you say PNDC Law 111, everybody knows that PNDC Law 111. But what does the law say in respect of the distribution of properties, in respect of intermeddling, in respect of, these outmoded customs, and especially in our rural areas, it's terrible. It's terrible. The widows the old customs that, Justice Taylor described as outmoded in his judgments, things like shaving a woman's head, putting pepper in a woman's eyes, the brother of the deceased man should marry the man's wife, and so on. It's still going on. It's still going on today. So we need more advocacy. And perhaps if we have some of our parliamentarians who are gender sensitive, I would suggest that we write out the debating points for them and push them to go and debate the bill in Parliament, and we have to be in Parliament for them to see us. We have to write out the debate for them. If you don't write it, they will not debate, even the women. And we have to educate them and push them to do the debate in Parliament. Thank you.
Thank you very much. I guess this is exactly what we're talking about, and Auntie Bessie mentioned it. Because imagine that you are married, you jointly acquire property with your husband, he passes. For all you know, you even acquired it. You know how our women were acquiring the properties and putting it in the names of their husbands. And then the man will die, and his stepchild from somewhere, all of a sudden, wants to come and occupy this property with you. Honestly speaking, yes, the law is that all children must inherit, but this is exactly the problem, because I will not feel comfortable. The person is a stranger. The person is not a loved one. I cannot stay in that house with that person. Let's be real. But the law is the law. So, but we want, I think Gloria wants to also contribute towards this.
A spouse, and he had 4 children, and after his first divorce he married her and they have a child. So when he passed, he has 2 properties, 2 houses, and so for years they've been wrangling about the LA. But finally I went to her and I explained to her that according to the Intestate Succession Law, the children, that's her child plus the other 4, are entitled to 9/16, which is approximately 56%. We did the math. And then she, as surviving spouse, is entitled to 3/16. And we did the math and it was 19%. And then the family, the surviving family plus surviving parents are entitled to what do you call it? 1/8, the rest, which is 25. So when we did the maths, it was 100%. So she's agreed that now she's going to share the matrimonial home. Well, she wants to relocate, so they will sell it. She and the 5 kids split it, and then when it comes to the other property, which is not the other one, they will have it shared between the family members, because the parents. Aged parents are dead, and then the customary successor and all that. So the 56 and 19 and 25 came to 100%. Thank you.
Thank you very much. We have, from the group of questions we took, we had one more, that we say this law is no longer serving us properly. What is the percentage of shortcomings? Is it an actual problem with the law now, or it is the problem of interpretation or implementation? But he wants a figure for the shortcomings. Yes.
I would say 80%. The law has, worked and helped a lot of people. I'll put it at 80%. There are challenges, the fragmentation, because they didn't separate the spouse's own from the children's own, people have to then come and share properties they are used to enjoying with their spouse alone with others. It causes problems. The issues about the polygamous marriages, and like I said, that division, the fractions is a problem. And but at the bottom of it all is lack of knowledge. As my big sister Georgette indicated, many people don't know it. They don't even know the processes to follow before you start the sharing. Okay, so I would say 80. So for me, if the law addresses the issue about the jointly acquired properties, even though there's now confusion with the Supreme Court as to what is jointly acquired properties, and then addresses some of the big problems, punishing those who intermeddle more strongly, as Mercedes has indicated a lot. So, but for me, the law has been very effective. Since 85, it has saved a lot of people. Otherwise, there would have been more destitute widows than we have now. So for me, I think that 80, I'll give it 80. Once the 20 is addressed, we will be, for implementation, because the law says you need letters of administration before you can share. the problem is that many people don't even know where to go and get this letters of administration done. Do you get it? It's not like the person has just died and then you are just sharing. You're supposed to go to court, go through, indicate who's going to be the administrators, etc. before you share. So long as you know about the court and go there and get the power to do the distribution, you're home and dry. But people really don't go, unless they get help. I know a lot of people go to FIDA and some of the legal aid places, and going for letter of administration is one of the cheapest legal services you can get. It's not expensive. So the information sharing to let people know how to access. Remember they said at the bottom line is access to justice. If you know and you go for it, you can even, LA is one of the ones that you can even go to court without a lawyer. When I started practice, the court clerks in the firm where I started in, they were handling it. So they will do the application, and then that day if you happen to be going to court, they'll say, oh, if you go to court, I have this small matter, just move it for me, because he can't go and move it. So some people go and see the registrar, if it's at small estates, at the district courts. So once they have access, they know and go and have access. It's not such a big deal. So the law, once you approach it, is able to help, but it's not the law that will distribute it for you. Once you get the power, then you're supposed to share in accordance with the law. Sometimes there are problems. The court also says you can come there to be able to address. There are issues to do with caveats. When you apply for letters of administration, sometimes you don't necessarily get it free. Some people will caveat to say that you've included some property which is not family property, or you're not the right person. The law says maximum of 4 people. So sometimes there are a few challenges when you apply, and then that has to be dealt with by the courts. But generally, I would say, if you know about it, so knowledge about the law is a very big thing and needs to be spread.
For time, so we'll take the last one question so that we can.
My lady, I'm coming. There's one hand. Please keep it short.
Okay, thank you. My name is Adoma Afokao, and I'm with the Gender Studies and Human Rights Documentation Center. So I would like to ask a question regarding, I don't know whether it's ADR or the intestate in general. So let's say somebody dies, then he had a wife, but he didn't have children with the wife, he had children outside. So they do an ADR, and the court decides to split the properties equally among the children and then the surviving spouse. So since the surviving spouse doesn't have children, can the children decide to take the house back when she dies, or it goes to the customary successor? And then I also like to know, I don't know, I'm wondering how we establish matrimonial home in terms of polygamous marriages. Thank you.
Our sister from AG mentioned that provision is going to be made somehow for side chicks. Say it again. Very well. So if that is the case, or I don't know what it is, but it appears there's room. There must be opportunity for more debates about the future of this amendment that we are seeking to have in the law that has lived for 40 years. Indeed, there are so many issues with it. So there's no need for rushing into passing this amendment. If there's time for more debates, I think that would be good. And then again, you mentioned the issue of statistics. I am aware that with every bill, there's a policy document that follows it. Was there something like a policy document? Very well. And I believe statistics are also captured in there, if you can throw a little light on that one.
The ADR.
Thank you. You were saying about ADR and then the court making a decision. ADR is not. When they go to ADR or mediation, it is the parties themselves who come out with their own solutions. The mediator does not enforce or tell them what to do. They come out with their own solutions, and then that is put down in a settlement agreement, and then the parties settle. So if they say that the matrimonial home should be given to the spouse, sometimes they can agree that it should be given to her for her life. I know a case where the man married a woman and then he had only one child with that woman. Then he has had about 5 children outside. Then when he made his will, he said the matrimonial home should be given to the spouse just for life. And unfortunately, just a few weeks ago, the woman's only child died. So it's now left with the side chick's children. So when the woman passes, it will go to the side chick's children. That's why sometimes it's important for us to emphasize that people to try and do their wills, you see, because those side chick children, they could have now come and start fighting, but the woman is still alive. So the will has protected her from them. And I hear they've been, since the woman's son died, they've been parading in the area, eyeing the house and so on. And so I called the executor and told him that the house is for the woman for her life. She's not dead yet. She's about 80. Maybe she'll live to 90 or something. So they should stay off. Thank you.
So part of the question was about what happens after she dies. So they agreed to share. They'll share it equally. She has about 25%. When she dies, since she doesn't have any child with the deceased, does her interest devolve onto the man's children, or it goes to her?
If they agree that when she dies, when her interest is 25% and it's absolute, then when she dies, it will go to her family.
Okay.
It will not go to the other children because they've agreed that it's her interest.
Okay.
So sometimes, that's why I was saying that sometimes they can agree that it is for life, for her life. But if they say hers is 25%, then it's for her. If she makes a will and even gives it to Osu Children's Home, that 25% will go to Osu Children's Home.
Thank you very much. So last one from you before we take final words from the panelists.
Okay, on the other women's side issue, so the memorandum to the Act looks at some of the loopholes, challenges, emerging issues with the law as it is, and it identifies polygamous marriages, it identifies cohabiting, it identifies informal unions, and all that. And that's what I'm saying. Some people think that it's encouraging side chick or is immoral. So we need to have more education to explain to people that this is what it is. It's not that we are promoting an immoral act or anything, because it's also going to look at, like I said, new forms of investments and properties that people acquire. There's crypto now. There are other things that you can't really see or touch, but they all form parts of a deceased estate. So it is engaging people, and Auntie Angela, your information is going to go. Auntie Fiba, I'll be calling on you. We need to have stakeholder engagements, like I said. NCC would have to come in, legal aid, the CSOs, NGOs and all that, so that we have a holistic approach to this thing. We cannot wait to have a perfect bill before legal correct. We cannot wait to say that we are fine-tuning everything to have a perfect bill before we pass it into law. Let's work with something. We have worked with this one for this number of years. Like Auntie Sheila said, it has helped a lot. So let's look at what we have now, and as quickly as possible. So I'm disagreeing with you that we shouldn't rush it. We should rush it as quickly as possible, get it passed. Then in 5 years, in 10 years, we can start looking at some amendments to it. But my final words in conclusion, let us take steps to safeguard ourselves, protect our families, and if possible, make a will. You have shoes, you have bags, you have clothes. Start with that. Prepare something, because you may think that when you die, the law will share your things, but there are some family members of yours you don't even see eye to eye with. But upon your demise, if we are applying this law, they are going to benefit under your estate. So take intentional steps to prepare and safeguard yourself, protect your family, so that we can peacefully move on. Because as for succession, it is there. Death is inevitable. It will come. So let's prepare ourselves and have a sound sleep, literally, when you pass. Thank you very much.
Quickly, let's take just under 1 minute final words from each panelist.
Thank you. I agree with my colleague. Let's all prepare wills. And then also we need more education about Law 111. I don't know whether now when they amend it, it will become an act, whether we'll still use Law 111. But I think we need to have it as an act, Intestate Succession Act. And then finally, I would suggest that from the ADR point of view, let's have a provision for perhaps cases that disputes to be resolved by ADR first before they go to court. Some of them can easily be resolved. In our association, we have over 300 mediators, and they are always willing and ready to resolve disputes.
Thank you very much. Madam Usua, last words.
Thank you very much. Before I do my last word, I also want to bring to the attention of the public that there's an emerging trend where now it's not only the women and children that are sacked, but rather one part of the family will take the children away and drive the spouse out. So it's become problematic these days. It happens to the men, it also happens to the women. So maybe going forward, we need to also look at these issues as well. So 40 years, I mean, at the time when the PNDC Law 111 was passed, some of us were still kids, and we are here. It was a game changer when you look back. It was a law passed at a time when it needed to be passed, and it saved a lot of lives. But 40 years is a long time to be doing the same thing the same way. A lot has happened within the 40 years. And so there's a need for us to go back and amend the law to suit the current situation. So for us going forward, there's advocacy and then the need to amend the law now. Thank you.
Thank you very much. And thank you
very much. I believe that we need to intensify activism, advocacy to ensure that this law is passed. In the late 2008, 2009, 2013, a lot of work was done, but it kind of waned. We need to revive ourselves again. And I think that judging from a recent experience, one of the best ways to do that, particularly for the side of civil society, is to come together as a coalition. You know, when you're trying to push for something alone, it's difficult. But if you come together with people of like minds, then it makes it easier to push. I know that around 2009, we tried to form a coalition. And at this stage, I'd like to remember one of our colleagues, Edna Kuma. We were on a lot of platforms pushing for this law. May she rest in peace. He passed away. So I think that the idea of a coalition, again, on property rights of women or something, because then it makes it more inclusive. You're not only looking at intestate succession, you're also looking at property rights of spouses. And once we come together, we can come as a force. And one group which I didn't mention when I was talking about sort of the way forward and how to approach it is the religious groups. The 2022 one and all the other previous ones, some of the groups that I belong to submitted memos to Parliament. A lot of the Muslim groups also submitted proposals, still pushing that they want to have their own sectarian law. They've told them already that from 85, there's one uniform law, so they can't have a separate one. There were about, the last one, the 2022 one, there were about 5 different Muslim groups that came with their proposals, pushing for the sectarian one. So people like that would not also like to have this law done. So in our approach, in terms of segmenting different segments of the population to approach and advocate, and the religious groups, you can't rule them out because they can also kill it. Because yes, they think that this law is still continuing to say that their own sectarian laws are not going to be recognized. They've still recognizing it since 1985. They pretend it hasn't changed, so they would like to use this opportunity to reactivate it. So a lot of work lies ahead of us. Let's get ourselves together. As I said, a broom, when it comes together, it's easier to sweep a room. If it's single, it can't go very far. So that we can push and use all the strategies we've had today to get for a change in law.
I'd like to say a big thank you to the panelists. Thank you so much for your overwhelming knowledge and expert advice. As we conclude this panel discussion, one message stands out clearly. This is not just a legal issue. It's a human issue. It touches grief, dignity, security, and justice. We've heard today that while PNDC Law 111 was instrumental and it has served Ghana well, there's a need to reflect contemporary family structures to protect the vulnerable better and reduce conflicts rather than to fuel it. So on behalf of Aula Ghana, I want to say thank you to our panelists for your thoughtful contributions. Thank you to Auntie Betty for setting the tone for this panel discussion. And for our audience, thank you to our audience for engaging us meaningfully. Let the discussion not end here. Let it inform advocacy, policy reform, personal decision making, especially the importance of estate planning. Make a will. Thank you all for your time, your attention, and your commitment to justice. Thank you very much. Thank you very much to Marian and her wonderful panel. You have done a wonderful job. We are so grateful to you all.
I think that Marian has done a good job at the vote of thanks, so I'm not going to say much. What I want to say here this evening is that we've been gathered by Aula to talk about the Intestate Succession Law. We've spoken about its relevance, challenges, and emerging issues. I believe that without any shadow of doubt, we've had a very good discussion, haven't we? So let's give a clap to. We have been enlightened, we have agreed, and we have also disagreed on the various elements and the topics under discussion. But on the whole, it's been time well spent. Now, our unqualified thanks go to Auntie Betty. And I just don't want to say much, but it goes without telling that she has championed this advocacy. She's done very well. And even the delivery, talking about experience, the things that have gone on. And we want to say a big thank you to Auntie Betty. I also want to say a big thanks to the panelists. I think that they've done a very good job. They have discussed, we have agreed, we have disagreed with them, we have thought that, oh, this, you shouldn't have said it, or that's whatever. It all brings to the fore that we have to continue discussing, especially to the students. We have to continue discussing this and to make sure that these great ladies who have held the baton up to this point, we will not allow the baton to be left, or we will not be last. They have run out to the front and they are still holding the baton. When it's handed over to you, please don't be last. Take it up. That's all that I want to say. Take it up. I want to end with a story, not a very long one. When we were growing up, we lived in an estate, sort of, so we were going in and out of each other's houses. One very early morning, we heard wailing. Apparently, one of our friends' father had died. And before he died, they were all in the main house, living as a family. When we heard that wailing and we visited the house, the woman with the 4 girls had been packed out of the main house into a very small one-room structure at the back of the house. And this woman had to take care of the children by selling by the wayside. Her husband was a contractor. The whole family moved into the main house, and she and her children were relegated to the background. Now, what I want to say here is that when it happened in my lifetime, those years, I didn't know that I was going to be involved in this.
You understand? We saw what happened. And fortunately for the woman, her children were very brilliant. So she has about 3 doctors and then one, businesswoman or something. You understand? So please, I'm telling you, the young ones, don't let the baton down. Hold it, and let's forge ahead. So I want to say thank you to all of you for making this gathering a very successful one. Thank you. Thank you very much, Auntie Fiba. We'll take a few pictures and that is it. But before we do that, I'd want to acknowledge the presence of a very special person in our midst who has just joined us. A few minutes ago, I called him and I informed him that would want to come to his office to say thank you. But in his usual spirit of humility and respect for all, he said, no, now let me come here. Let me come here. We have been joined by the man under whose visionary leadership this university is running. He's the Vice Chancellor of the UPSA, Professor Kweku Mensah Mauto. Please, let's show some appreciation to Professor Mauto for joining us and for hosting Aula and all of us this evening. Prof, we are very grateful. We don't take your hospitality for lightly at all. God bless you for all that you do for this university. So, ladies and gentlemen, this has been the public lecture delivered by the Honorable Betty Mould-Iddrisu on the theme, the Intestate Succession Act 1985, PNDC Law 111 at 40, Relevance, Challenges, and Emerging Issues. On behalf of Aula and the entire management of UPSA and the UPSA Law School, thank you so much for being here with us this afternoon. God bless us all.